My lord, with your lordship's kind indulgence, I'd like to mention item number 3, my lord, little bit of accommodation, my lord. If your lordship take it at 2 p.m. my lord. Oh, much obliged.
With your lordship permission, I beg for listing of a matter pending since 2018 and IA has been filed. So can it come on 30th October, lordship?
Okay.
Lordship.
May please be, my lord. Lordship, I would like to mention for admission to MSc appeals on 24th, lordship, Friday, lordship. And one,
Admission, what is the urgency?
no, lordship, they did delay for no long back, lordship, but it is not listed.
Okay.
And one order for delay condition, one MSc appeal for orders.
Okay.
That will be lawful.
I beg to mention item 13, my lord. My name, the name of Alamgir and S.K. Nur Muhammad are shown. My lord, what happened? The file has been taken that on 25th, 6/2020. The one of the appellant has taken back the file from us, and he wanted to engage senior advocate G.P. Bhomik. I don't know what has happened. Now our names are appearing, but no other name, if anybody has been engaged, it is not shown. We are not in the case, my lord, now.
Whether newly engaged counsel have filed
No,
any
no,
wakalat?
we made some inquiry. What happened, my lord? Unfortunately, after taking the file, learned senior counsel G.P. Bhomik had some family problem, and after that he is not coming to the court now. And the party, his phone number also could not be found now. And somehow he may be contacted and informed that his case is without any.
This is. Okay. Heard, Mr. You have informed the other side.
Yes, already. Other side means, my lord, we have not informed. Because this, I wanted to convey the honorable court on it.
Then.
I can inform Subhash Sesana.
Then we'll pass the orders when the matter is called up. When the matter is called, we will pass the orders because other side does not know about mentioning.
Okay.
We'll.
Lordship, I'd like to mention item number 20. Lordship, I have got some personal difficulties today. If it can be in the next week, Lordship.
You have informed the other side. Heard Mr. R.K. Deva Chaudhary, learned DSGY, learned counsel, appearing for the respondent who prays for an adjournment on some due to some personal difficulties. Mr. A. Dhar, learned counsel for the appellant, does not have any objection to the same.
That will be taken up on 30th October.
That's fine, Lordship.
Next week.
Let this matter be listed on 30 October for hearing.
My lord, I beg to mention, my lord, there is to 5 MSc appeal, which was date was fixed for 27/9/2024. From then, the matter was not listed, my lord. So it may be listed on 28 October. my lord.
No fixed date.
Next week,
In the first week of November on a date to be fixed by registry.
21st.
First week of November.
That's
My please, Lordship, I'd like to mention for urgent of listing MSc appeal 89/2018.
What is the urgency?
Urgency for order, Your Honor, Lordship. It is a long pending case, 2018. Your Honor. On last on 21/9/2022, the matter
In
has
the
been-
first week of November.
May I please, Your
will
Honor?
be obliged.
But I beg to mention for listing of a regular second appeal, my lord. In this case, my lord, title execution case is started, my lord. My lord, last date fixed on 29/10/2025 for report, my lord. Kindly take-
First week of November.
my lord, title execution date fixed on this month, my lord. Can it be a Monday, my lord?
Okay, on Monday.
Most obliged.
May I please, Your Lord? I beg to mention for listing one RSA lordship, 2019 matter lordship,
For hearing,
hearing lordship.
second week of November.
Another prayer lordship. One transfer petition may be list, Lordship. On Monday, Lordship.
Fresh matter,
No, Lordship. 2024 matter.
first week of November.
Date may be fixed.
No, no dates.
Lordship. My place, your Lordship. I beg to mention item 17, Lordship. 4 weeks time may be granted.
Have you informed the other side?
Yes,
Heard Mr.
as H. Ram. H. Ram.
S.H. Rahman, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty. Also heard Mr. Ainuddin, learned counsel for the respondent, who does not oppose the prayer, hence the prayer is allowed. Let this matter be listed after 4 weeks.
Obliged.
May please your lordship, I beg to mention on review petition. The review petition filed on 14th of October. The matter yet has not listed, therefore, on, if my lord may allow, then 30
Oh,
of,
first week of November.
30/10, my lord.
No, you cannot choose dates. First week of November.
May it please your lordship, I beg to mention for listing of two RFA, connected the same titles to lordship. This is the order column lordship. And matter has been pending since long,
Oh,
2020.
first week of November,
A specific date may be lordship.
second week of November.
The one second appeal was filed yesterday, my lord. Execution case, execution is fixed on 27th, my lord, on Monday. May I pray for tomorrow, my lord?
Okay.
Obliged.
May I please your lordship, Lordship, I'm praying for listing of a hearing matter, Lordship. It is not listed since long, Lordship.
Hearing
Yes, it is a CRP, Lordship, a civil revision petition.
second week of November
Second week.
on a date to be fixed by registry.
Yeah, please, your lordship, I beg to mention an RSA for listing for orders. My lord.
Second week of November.
May I please your lordship? I beg to mention item number 14, my lord, with the consent of the other side, my lord. The matter may be taken up after 4 weeks as a compromise has been reached between the parties, my lord. We are only due to file one interlocutory application to bring on record the compromise. Sir.
Heard Mr. S. Sancheti, learned counsel for the petitioner, who submits that a compromise has been arrived at between the parties, and prays for submitting the deed of compromise. Who is for the other side? Also heard
J. Sharma.
Miss J. Sharma, learned counsel for respondent number 1, who also conforms to the submissions made by learned counsel for the appellant. The prayer is allowed. Let this case be listed after a week,
4 weeks, my lord,
after 4 weeks,
because there are
before-
number of parties.
before a bench without me. Within bracket my name likhe, mon naam likhe.
I utilize it, lordship.
May I please your lordship? I'd like to make, I beg to make, mention of some matrimonial appeal. That was listed last June 4th of April 2024. So the matter may be listed on
Or
4 orders.
second week of November.
May I please your lordship? I beg to mention of a urgent listing for tomorrow, my lord. It matters relates to first appeal from order, my lord. So there is some urgency. The petitioner.
What is the urgency?
The applicant, the applicant is a circle officer, Dhubri, and he has been constantly facing defamatory statements by a young lady, and statements are being published on newspapers, my lord. So it will be listed on tomorrow, my lord.
Okay.
Mr. Please.
May please your lordship. Lordship, with the consent of the other side, my lord, I beg to mention item number 16, my lord. My senior is now out of station, my lord. So matter may be fixed after 4 weeks, my lord.
What is your name?
Arrive here, my lord.
R.I.P. We are learned counsel for.
Appellant.
Who is your senior?
My lord, appellant,
Who is your senior?
Anis Mazabuya, my lord. My lord, newly engaged, my lord. Today we have Okalata file already.
Okay. Mr. R.I. Bhuvan, learned counsel for the appellant, prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. he submits that he has informed the learned counsel for the respondent regarding his prayer for adjournment, who has no objection to the same, as the prayer is allowed.
Here for listing of a motion matter, it is the RFA
Motion,
motion. My lord,
Mm,
310 it was filed, 310/25 it was filed, not listed. I
Monday.
am deeply obliged.
May I please, your lordship, I beg to mention for listing of a CRP for admission lordship.
When do you want?
Lordship, next week,
Okay, next week on a date to be fixed by registry.
much obliged.
May I please, your lordship? I beg to mention for a listing of a transfer petition, any day on the next week, your lordship.
Okay,
File your.
May I please, your lordship, I beg to mention one RSA for listing in orders column. Can it be on Monday, lordship?
next week on a date to be fixed by registry.
I think what.
Right. Well, in this case, notice was issued to the father of the alleged victim. It is received, affidavit is filed. Case was of child marriage, my lord.
Why it has come in motion column?
It was supposed to be come for bail hearing. But,
The CD has not been issued.
Okay,
and
the respondent number 2 has appeared.
three,
For the respondent number
but he
3.
directed me to, because he is not informant. Informant is the Panchayat secretary. And Lordship directed me to file amended cause title, implementing him.
Okay,
He has filed
heard
affidavit.
Mr. K.M.
Lord, may I
Halloway.
submit one thing, Lord?
Yes.
Already it is, trial has started, my lord. After passing of the interim order. I am on interim. And, charge sheet was filed. And, already copy served. Now next date is fixed on 11th of November for consideration of charge.
What is your prayer?
But, Lordship, as he is, appearing regularly, Lordship will make it absolute and she doesn't have any objection in affidavit. As stated there, married
I
and
have stated in my paragraph 3 of my affidavit.
3, 4 and 5. I have gone through.
The application was filed during the stage of investigation.
Yes.
In the meantime, lordship, as per their commission lordship, charge sheet has been filed.
Sir, already case number, Lord, it is special POXO case number 40 of 2025. Next date is on 11th of
Okay,
November.
he is cooperating in trial.
Yes,
We can make it absolute.
What?
Heard Mr. K.M. Halloway, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Miss, what is the
He does.
B. Das appearing for respondent number 3. It is submitted at bar. It is submitted by learned counsel for the petitioner. That petitioner was granted interim bail by order dated
18/9.
18/9/2025. And in the meanwhile, charge sheet has been laid. He further submits that you have appeared,
Appear copy received below.
he has appeared before the trial court and is cooperating in the trial. Stop. Learned counsel for respondent number 3 within bracket victim has also submitted that she has no objection if the interim bail granted to the petitioner by order dated 18/9/2025 is made absolute, as the petitioner is cooperating in the trial. Considering the submissions made by learned counsel for the parties, as well as considering the fact that the petitioner has been cooperating in the trial, the interim bail granted to the petitioner by order dated 18/9/2025 is hereby made absolute with a condition that he shall continue to cooperate in the trial.
Much.
I think to. Your lordship. My lord, this is a regular bail application, my lord. Although the petitioners earlier approached your lordship by way of filing an anticipatory bail application, my lord, when NBW was issued against them.
Now, whether charge sheet has,
It has been filed, my lord. during the pendency of the AB, my lord, that was earlier filed, which was disposed on, my lord, on 4/6/2025 by this honorable court, my lord. This court gave a direction, my lord, to appear before the trial court within 15 days, my lord. Also, the suspension of NBW was also suspended, my lord.
Thereafter,
They appeared, my lord, within that period, and they filed the regular bail application. But
It was filed in the year 2024, Lord Ship. They appeared in 2025, Lord Ship.
then bail is rejected.
bail application was rejected, my lord, and they were detained and arrested, my lord, during the period of suspension of the NBW. The NBW was suspended, my lord. Kindly see page 21, my lord, of the order of the AB, my lord.
No, you surrendered or you were arrested?
My lord, I appeared, I surrendered as part of the, in terms of the order of this honorable court, my lord. I appeared within the stipulated time period, that is 15 days, my lord.
Yes,
Appeared before the trial court in terms of the summons, my lord.
yes.
And I filed a regular bail application.
Bail was rejected.
Rejected, my lord, and I was detained, my lord. And since then, my lord, all the petitioners are behind bars, my lord. It is 4 months, 10 days, my lord.
Scan copy may be called.
Scan copy would be required.
My lord, in the interim, my lord, at least petition number 1 and 2 may be released, my lord. They are 70 years and 60 years of age, my lord.
They remain absconding, Lord Ship. FIR was lodged in the year 2023. They remain charge sheet. was
What is
filed-
the case?
My lord, FIR is at page 14, my lord.
Who was killed?
My lord, here the victim is, my lord, the wife of accused number 3, my lord. And a minor son was also a victim, my lord. He was also the son of accused number 3, my lord.
304B, 302 and 34, Lord. 302 is also there, Lord.
Yes, my lord. 302 is there, my lord.
So it is the records may be called for, Lord.
But my lord, the petitioners here, my lord,
Okay, we'll go through the record.
Yes.
Because trial court has rejected your prayer. Heard Mr.
SS Ahmed, my lord.
S.S.
Ahmed.
Ahmed, learned counsel for the petitioners. Also heard Mr. B. Sharma, learned additional public prosecutor. Perusal of the scan copy of the trial court records as well as scan copy of the connected case diary would be necessary for consideration of the instant bail application. Hence call for the same. Registry to take steps for requisitioning the scan copies. Let this case be listed when?
Let a short date, my lord.
1411, Lord.
My lord. 14, First week of November.
10th of November.
Well.
10th of November.
Achha.
Item 22 from supplementary list.
Mhm. 22. Any criminal matter remaining?
Item number 5, 6 and 7. 6 is for NCB, Lordship. Ours is 5 and 7, Lordship.
We'll take up after this motion item. We'll finish the criminal items first. Yes. Now you can.
Yes, Lordship. Lordship, here the civil revision is against the order dated, my lordship, at annexure 9, relevant page 63. My lordship, what happened was that we have filed a petition, to file a petition under order 9, rule 13, my lordship. There was a delay of 209 days, my lordship. And with regard to that, we have filed a petition under section 5, my lordship, and that was dismissed, my lordship. Page 63 is the impugned order, my lordship. My lordship, here the
Ex parte decree was passed.
expert. My lordship, initially there were total 15 defendants, out of which some expired and total 14 remain, my lordship. We are here 9 petitioners in the civil revision petition, my lordship. Out of 9 petitioner, my lordship, petitioner number 4, 6 and 8, they engage an advocate. My lordship, and on the first day, the advocate sought time for filing WS, and thereafter the advocate did not appear, my lordship. We came to know about the same when the execution notice was received, my lordship, with regard to petitioner number 4, 6 and 8, my lordship. And with regard to the other petitioners, my lordship, they received notice, but because, my lordship, because of their condition, they did not appear before the court, my lordship. They received notice, that is an admitted part, my lordship. And the original, my lordship,
Receive notice of
notice of the original title suit,
summons.
my lordship. summons
Okay.
Of this suit. And with regard to four.
In spite of that, they failed to appear.
Yes, my lordship, that is a fact with regard to the other petitioners.
And you,
I am for total there are
Nine.
nine. Out of nine, petitioner number 4, 6, and 8, they engaged in advocate. Advocate did not appear.
how many petitioners? You are
Nine
appearing for all?
Appearing for all, my lordship. 9 petitioners, this is a total.
4, 6, and 8.
Yes, with regard to 4, 6, and 8, my lordship, the advocate did not appear. The first day,
And with regard to others petitioners,
they did not appear, my lordship. They,
in spite of receipt of, then why this court should be lenient towards you?
my lordship, that is true, my lordship. And with regard to 4, 6, and 8, my lordship, with regard to petitioner number 4, 6, and 8, their cause was that the advocate did not, my lordship, they are from a very downtrodden, my lordship, they are living below poverty line. And this is with regard to their dwelling house, my lordship. These petitioners are extremely poor, they are pre-tribe community people, my lordship, and they are running from one place to another, doing daily wage labor somehow.
Which is the impugn order? 6/8,
63, my lordship.
6/8/2025.
We have moved a petition.
What
for-
is the error?
The error with regard to, my lordship, the error with regard to specifically not considering, my lordship, we'd expect 2 points with regard to not considering the petitioner number 4, 6, and 8, my lordship. 4, 6, and 8, because the advocate did not contest and they were not aware. Only after the execution notice was received, someone was received, they so-called notice was, they came to know. And with regard to other petitioner, with regard to ground, we have stated that they are to consider it a little leniency since they are, this is their dwelling houses and they are below totem and living just bread and butter up to mouth, they are living, my lordship.
No, but court considered,
Yes,
did
my
not
lordship.
consider it to be sufficient cause.
My lordship.
After considering this,
My lord. And even in the order also, it is reflected, my lordship. If in the impugned order, may I take your lordship to page 63, my lordship, for a second, paragraph number 3.
yes.
May I read, my lordship?
Yes.
The main contention of the petitioner is that the plaintiff filed title suit number 28/2023 against them for recovery of possession and permanent injunction in which they have received summons, and accordingly petitioner number 4, 6, and 8 appeared before the court and prayed for time to furnish their written statement. That however, on the next date, that is 14/11/2023, their engaged learned advocate did not appear before the court, for which the court was inclined to proceed ex parte against them in title suit number 28/2022, Bite order dated 14/11/2023. With regard to petitioner number 4, 6, and 8 specifically, my lordship, they were not aware. They have given their requisite fees and documents, but the WS was.
What is the suit property?
Uh,
9 different rooms,
my lordship, yes, dwelling houses, my lordship.
9 different houses or a common
Yes.
house.
Yes, 9 different houses, my lordship. There were dwelling houses, with a total land is 8 bigha 3/13 losses, my lordship. In which, my lordship, their eviction and demolition of their houses is their suit prayer, my lordship, in which the decree was passed.
What is the irregularity or
Uh,
illegality?
With regard to the impugned order.
Impugned
My
order.
lordship, there is, my lordship, with regard to petitioner number 4, 6, and 8.
It
There
was
were-
considered, your plea was considered and was not found to be sufficient.
My lordship,
That is a finding.
that is a finding, my lordship.
Is it an illegal finding?
It was not within the knowledge of the petitioners, being they belonging to a very poor strata, the advocate having not informed them, my lordship, they may be considered as a sufficient cause, my lordship.
Heard Miss S.J. Barua, learned counsel for the petitioners. This application under section 115 of the Code of Civil Procedure, 1908, has been filed by the petitioners impugning the order dated 9/5/2020.
My lord, 6/8/2005.
6/8/2025. Passed by the Court of Learned Civil Senior Division Lakhimpur, North Lakhimpur, in Ms. J case number 1/2025 in connection with title suit number 28/2023, whereby this was for condoning the delay,
Delay, my lordship, 200.
whereby the delay of 219 days,
9 days, my lord.
209 days in filing the application for setting aside ex parte decree was dismissed by the trial court. Learned counsel for the petitioner submits that the petitioners pleaded before the trial court that after receipt of notice summons in title suit number 28/2023, the petitioner number 468 engaged counsel and prayed for some time for filing written statement. However, on the next date, that is on 14/11/2023, the engaged counsel defaulted to appear before the trial court. Stop. It is submitted by learned counsel for the petitioners that the engaged counsel did not inform about his default in appearing before the trial court to the petitioners, and therefore petitioners were unaware of the fact that the suit proceeded against them ex parte. She submits that the trial court erred in not considering the said ground to be sufficient cause for condoning the delay of 209 days, as the suit as over the suit property, the petitioners have constructed their dwelling houses and are staying there. Stop. The contention raised by learned counsel for the petitioners needs to be examined. Hence, issue notice to the respondent. Sole respondent, two respondents.
Two respondents.
Issue notice to the respondents and call for the records of Ms. J case number Ms. J case number 1/2025 as well as title suit number 28/2023 from the trial court. Any execution case has been
Chief execution is annexed 10, my lordship. It is fixed tomorrow. Title execution number 6/2024.
stop. The petitioners shall take steps for issuance of notice upon the respondents by speed post within 7 days from the date of this order, returnable on 21st of November. Stop. Learned counsel for the petitioners has submitted that in the meanwhile, respondents have already instituted and execution case which has been registered as execution case number
6/2024.
6/2024. And same is fixed before the executing court tomorrow, that is 24/10/2025. Stops. Considering the submissions made by learned counsel for the petitioners, the aforesaid execution case, the proceedings of aforesaid execution case within bracket title execution case number 6/2025 shall remain stayed till next returnable date. List accordingly.
Yes, my lordship, highly obliged.
PP9.
Well, Lordship, we are directed to take instruction of service, Lordship. I tried, Lordship, I do not have the information, Lordship. Amicus may be appointed. On the last occasion also, Lordship, one amicus was appointed. MK Brown, preferably, Lordship, if possible.
MK Brown has been appointed, already
Earlier-
appointed
Earlier occasion.
Earlier occasion.
in this case.
Yes,
Yes, in this case. It is second time. no?
This is the second time,
Third time.
third time. Heard Mr. S.H. Sigdar, learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor, who submits that he would not take information regarding service of notice on respondent number 2. Neither any service report has been received till date. He therefore prays for appointment of an amicus curiae to defend the cause of respondent number 2 in this case. Stop. Considering the submissions made by learned counsel for the learned additional public prosecutor, this court is inclined to appoint Miss M.K. Brown, whose name appears in the list of amicus curiae as amicus curiae in this case to defend the cause of respondent number 2. The registry is directed to reflect the name of Miss M.K. Brown as amicus curiae for respondent number 2 in the cause list henceforth. The petitioner is directed to furnish copy of bail application along with annexures to the newly appointed amicus curiae within 2 days from the date of this order. The scan copy is there.
Yes, reports are there. Lordship.
Kindly
The-
be shorted.
Records of the scan copy of the case records have been received. Please this case for bail hearing. POXO case.
My lord, Article 22 also not complied, my lord, grounds of, on similar ground, my lord, another query request already has been released, my lord. So kindly short it, my lord.
Which date?
My lord,
Suggest.
my lord. 28,
10th.
28.
28, 2 days, within 2 days, you have to furnish the copies to the
My lord,
amicus.
today itself, my lord, I will furnish. My lord.
It is on 31st, Lordship.
On first of,
First one.
My lord, another case, my lord,
First is,
regarding same,
Friday,
same, my lord, is fixed on 30 also already, my lord. BA 3112, my
okay, on 30.
lord. 30. Obliged.
NCB Arsenic Council. Madhuk.
Item 6 and 23.
May I please, your lordship? Your
Please, your
lordship, the matters may be adjourned for the day as it will be difficult for Mr. KL to appear today.
Both the matters.
It's your lordship. We are tagged.
Bishop, earlier also they have taken.
Today it will be difficult for Mr. KL to appear, your lordship.
Heard Mr. K. Thakur, learned counsel for the petitioner. Also heard Miss N. R. Hussain, learned counsel for NCB, who prays for an adjournment on the ground of difficulty of the personal difficulty on the part of standing counsel for NCB. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed.
28th of October. 28th,
Lordship, on 28th, Lordship, I may not be Lordship, 29, Lordship.
29th.
On 29th of October.
Give to your place.
Seven.
Seven lots of charge sheet has been submitted.
Yeah, so Lordship.
Charge sheet has been laid.
Yes.
You are on interim.
No. NDPS.
It has become in. Heard Miss L. Bunny, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number
285/25 dated 20/08/24.
in view of the laying of charge sheet. This anticipatory bail has become infructuous. And accordingly disposed of.
For admission, item 4.
May it please, my lord. I'm for the respondent number 1. My lord, yesterday I filed one affidavit in the incident matter. It is not on record. Affidavit in opposition again.
Yes,
My lord,
let it come on record.
In
Ah.
the interim continues, my lord, and next day if required, we file exchange this.
Heard Mr. M.J. Burra, learned counsel for the petitioner. Also heard Mr. P.R. Sharma, learned counsel for respondent number 1. Mr. K.R. Padgeri, learned counsel for respondent number 3, and Mr. B. Haldar, learned counsel for respondent number 5. Counsel for respondent number 2. Stop. Learned counsel for respondent number 1 has submitted that the said respondent has filed an
affidavit in opposition.
affidavit in opposition. However, same is not available in the record. The registry is directed to place the said affidavit in the record and list this matter when? After 2 weeks. After 2 weeks on a date to be fixed by registry. The interim order shall continue. The interim order is there,
Yes.
shall continue till next day.
Deeply obliged, deeply obliged.
Order, item 8.
Please, your lordship. Lordship, as per last order dated 29/8/25, the matter was to be listed in the hearing column, lordship.
Hearing,
It is wrongly listed today.
it is ready for hearing.
Otherwise,
it-
record has come, my lord. What happened, my lord, the person number 3 died. Thereafter substitution was there. So I am appearing for a substituted person, my lord,
Now substitution is over.
over. So record has come, my lord. So matter may be posted for hearing.
Heard Mr. What is your name?
M. Ahmed.
M.
Ahmed.
M. Ahmed, learned counsel for the appellant. Also heard Mr.
MK Mish.
M.K. Mishra, learned counsel for respondent number 1, 2, 3, within bracket 2, 3, 4, 4 and 5. It is submitted at bar that this appeal is ready for hearing. And accordingly, it is prayed that same may be listed for hearing. The prayer is allowed. Let this matter be listed for hearing in the
Can you fix the date?
3rd week of November on a date to be fixed by registry.
Or first week of December, because my lord, my advocate who is assisting me, my lord, he is facing some medical ground.
In the 1st week of December only.
Will be fixed by registry.
On a date to be fixed by registry.
Item 9.
this case,
Thank you, Your Lordship. My Lordship, he has also filed some petition I have not received, Lordship, first of all. Second, Lordship, last order is not complied on. Matter may be fixed after 1 week.
may I submit your lordship?
Yes.
This honorable court, in IA 1610, that was, filed for stay of the interim judgment and decree on the last occasion as per order dated.
1610 dio.
Yes. This honorable court was pleased to, stay the interim judgment and decree, on, depositing of 50% of the decretal amount. Now, the next date fixed in the executing court is tomorrow, your lordship, 24th. After
Have you
17th,
deposited?
that will be deposited by tomorrow, your lordship. On 17/9, the order has been communicated to the court and next date is fixed is tomorrow, your lordship, but today is closed. So we will, our part, we will pay and we will comply the honorable high court's order by tomorrow, your lordship.
Okay.
So that, for that purpose, I am praying that the matter may be fixed in the first week of November, your lordship. And we will even submit a certified copy of the same also, after we submit our part, your lordship, deposit our part here.
That stay petition is disposed of.
Already been disposed of.
Disposed of. So further order is not required. If you deposit tomorrow, then it will be stayed.
Then
If
did
you,
you-
if you,
Until next date, and by tomorrow we'll pay our part, your lordship. The appellant, your lordship.
Still not paid.
and in RSA, is it
In
ready?
the applications for substitution of the legal heirs of deceased respondent number 5. Now, what happened, your lordship? After the TCR has come and I have gone through, we have recently, tomorrow morning, we have filed 2 applications for withdrawal of the IAS and striking out of name of the respondent number 5 on the ground that the concerned deceased respondent number 5 did not contest in the suit, even did not file his written statement, that everything has been, we have elaborately submitted or pleaded in our IAS that we have filed today morning at 10:30, your lordship. So these applications may also come on the next fixed date, your lordship. One is for striking out and one is for withdrawal of the IAS, your lordship.
RSA to order করব. Heard Miss Soma Dasgupta. Learned,
7, 8, and 9 the RSA
learned,
for the state of Assam respondent.
learned counsel for the appellants / applicant, common order. Also heard Mr. A.H. Alamgir, learned counsel for respondent number 1 to 4. Also heard Mr. K.K. Bhattacharya, learned government advocate appearing for respondent number 7, 8, and 9. Also heard Mr. A.S. Tapadar, appearing for respondent number 6. Learned counsel for 10. What is your name? Heard Mr. S. Datta, standing counsel. Learned standing counsel, Revenue Department, appearing for respondent number 10. It is submitted by learned counsel for the appellant / applicant that the appellant has filed another interlocutory application for withdrawal of the interlocutory application number 3583.
IAS civil, your lordship, 3 IAS, IAS civil.
All 3 you want to withdraw.
Don't have any objection.
I have even got the serial numbers, your lordship.
Okay, withdrawal of I number 3583/2024, I number 819/2025, and I number 820/2025. However, the said interlocutory application is not yet placed along with this regular second appeal. Hence, she prays for listing the matter after a week. She also submitted that the execution of the impugned judgment and decree was stayed by this court by order dated
11/9/2020.
11/9/2025, passed in IA number 1610/2024, subject to the condition that the applicant shall pay 50%, shall deposit 50% of the decretal amount.
Applicant along with respondent number lordship 5 your lordship. Sorry, lordship Ajimuddin, respondent number 6 your lordship.
Who
Respondent number 6 your lordship.
you will also pay
Six.
along with respondent number 6 shall pay the decretal 50% of the decretal amount as a condition precedent for stay of the execution of the impugned judgment and decree. She submits that the execution case is fixed before the executing court tomorrow, that is on 24/10/2025, and the appellant/applicant would be depositing the 50% of the decretal amount as per the in person to this court direction tomorrow before the executing court.
His part he will pay your lordship.
Okay.
And his part he will pay out of 50%.
Appellant will deposit, his part. Stop. Let this matter be listed when? In the second week of November. In the second week of November, on a date to be fixed by registry. The interim order shall continue till next day.
Idea well.
Item 10.
May I please, your lordship?
Yes,
Lordship, in this matter, the LCR has not been received, lordship.
heard Miss, what is your name?
F. Ahmed.
F. Ahmed, learned
M. Hussain Malik.
counsel for the appellant. Also heard Mr. M. Hussain, learned counsel for the M. Hussain or Haq?
M. Hussain Malik.
M. Hussain, learned counsel for the respondent. On perusal of the office note dated
17/10.
17/10/2025, it appears that the case record of the title suit number 61/2000 has not yet been received from the trial court. Stop. Issue reminder for the same. Registry to take steps for issuing reminder. Let this case be listed again after 2 weeks on receipt of the aforesaid trial court records.
Lordship, the interim order may be
The
continued.
interim
lordship.
order shall continue till next week.
Most of the.
Deeply noted.
Fourth hearing, item 11. That on 28/8/2025, my lord, this matter was heard by his lordship, my lord Soikia, my lord. If your lordship will peruse the order, my lord, our part was over, my lord. As the respondent were not present, my lord, that the matter was deferred till today, my lord.
But it was not kept part heard.
Yes, my lord.
What is to be done?
As your lordship wishes, my lord.
No,
may I-
you, sir. You submit what is to be done.
May I pray, my lord, if lordship wishes, my lord, lordship may defer the matter, my lord,
Okay. Heard Mr.
P.K. Bhuya.
P.K. Bhuya, learned counsel for the appellants, who submits that on 28/8/2025, this appeal was heard by another coordinate bench of this court, within bracket by Honorable Mr. Justice P.J. Soikia. However, on that day, respondent was not heard not present and could not be heard. Stop. Today also, no one has appeared for the respondent on call. Let this matter be listed after
A week, my lord.
after 2 weeks.
A week.
or After a week on a date to be fixed by registry.
I'm deeply obliged. ma'am.
Yes. Yes, make your submissions.
Difficulty lordship.
What difficulty?
Lordship, Mr. Kyal not appear lordship.
So you argue the case. What is your prayer?
Next week lordship.
You are praying for adjournment. Heard Miss N. Kakoti, learned counsel for the appellants. No one appeared for respondent on call. Learned counsel for the appellants has prayed for an adjournment on the ground of personal difficulty of the conducting counsel for the appellants, Mr. S.C. Kyal. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks on date to be fixed by registry.
Lordship, on behalf of Mr. S.C. Vishwas, I'm paying for the time being. He's moving before court number 25. He will be coming right now.
Okay, heard Mr. M. Alamgir, learned counsel for the appellant. Also heard Miss, what is her name?
Devasri Chakraborty.
D. Dotto,
Chakraborty.
D. Chakraborty, learned counsel for the respondent. In fact, the appellant has made a prayer for adjournment in the morning hours.
Serious instruction to pray for the time being. That's why I'm praying for the time being.
Okay. Learned counsel for both sides prayed for an adjournment on the ground of personal difficulties. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
I'm for the respondent.
Lordship, my senior Mr. SP Rai is on his way. If the matter could be time being for the matter.
At 2.
At 2. Not at 2, in the second half. At 2, we have fixed matters.
Yes, second.
In the second half. Yes.
Yes, Your Lordship. Your Lordship, kindly the matter may be taken up with two Lordship. Due to some personal difficulty, the engaged counsel has left the court. She will reach by 2 Lordship.
Yes. Second half. Let her come. In the second half, we will take up the matter.
19.
It is testamentary appeal. And they have also filed a cross objection.
Yeah, they are not here.
Who is appearing?
Mr. Shahiola.
So what is to be done?
It will come after another day.
Lordship, my senior is in legs on court number 23.
What is your prayer?
Lordship, maybe taken after some time.
Not sometime. We'll adjourn it for the day. Heard Mr. S.D. Purkasta, learned counsel for the appellant. Also heard Miss, what is her name?
S. Agarwal.
S. Agarwal, learned counsel for the respondent / cross objector, who submits that, who prays for an accommodation as the learned senior counsel for the respondent / cross objector is on legs in a different court. The trial is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Item 21. Item number 21.
In item 13, my lord, I am appearing for the respondent in item 13. my lord. I could not appear when the matter was called up. Item 13, I am for the respondent. my lord.
Item number 13, show the S. Vishwaswar Hoy M. Chakraborty appear করেছে না? তেওঁৰ লগত show the name of Mr. A. Rahman. For respondent number, Mr. Vishwas is also appearing
My lord, I am also
with him.
my lord.
So somebody appeared.
The date may be fixed, my lord.
No, we have already passed the orders. Somebody appeared and we have passed the orders.
Obliged, sir. My lord, date may be fixed, my lord.
No. We
Otherwise,
have,
the matter will not be listed, my
we
lord.
have already passed the orders. You are late.
Right.
Who is appearing from for item number 21?
My secretary is coming just, I called him.
Lordship, my senior is the legs in court number 1, your lordship. Matter I fixed for Tuesday, Thursday, your lordship. There is no urgency.
It's a pleasure, my lord. So, give it to me, my lord. Thursday.
Lordship, can I be fixed for Thursday, your lordship?
Next Thursday.
Lordship.
Heard, miss, what is your name?
P. Shaha.
D. Shaha, learned counsel for the petitioner. Also heard Mr.
T. Gogoi.
T. Gogoi, learned counsel for respondent. Joint request has been made at bar to fix this matter on coming Thursday. That is on 30 October. Sorry, the prayer is allowed. List accordingly. Khatam. Yes, Mr. Roy.
Item number 15. For hearing, but the
15 due.
respondent has not reached.
He is on like, let them matter start from the appellant side. My senior is on that.
It is
For respondent.
What is to be done?
taken some other day.
No,
No, only
No.
I am ready to
no,
Tuesday.
my lord, so this is a all pending matter, 2017 matter.
Only I am ready
the-
for Tuesday.
In the both side, this is the landlord tenant matter. This matter taken up today. My lordship. This is.
I am ready, but you are not ready.
We are ready. Response side is ready.
We'll take it up in the second half at 2. If at 2 your senior remains absent, we'll adjourn the matter.
It's on
It
like.
will be taken Tuesday, Lord. Today, in second half, I am some personal difficulty.
Let my senior maybe come.
Heard, Mr. Kiman item number. Heard Mr. S.P. Roy, learned counsel for the petitioner. Also heard Mr. What is your name?
Peter Korea.
Peter Korea appearing for the respondents. Learned counsel for the petitioner prays for an adjournment on the ground of personal difficulty on his part in the second half of the day, as the counsel who is to argue for the respondent is on legs in a different court. Stop. Considering the submissions made by learned counsel for both sides, this matter is adjourned for adjourn. Let it be listed again on which date? Tuesday. Tuesday. You are agreeable to Tuesday, Mr. Roy?
Yeah.
Let this matter be listed again on 28th of October.
Oh, Lordship, sorry, on that day, 27, 28, Chhat Puja, our Chhat Puja. So it can be taken on 29th or
Thursday.
How you forget Chhat Puja?
Lordship?
It's on 2 days.
2 days, Lordship, 27, 28.
We already.
31. Then next Tuesday, 4th of November. 4th of November.
Public.
Was list. Yes.
Lord, possibly she has something to say.
Prayer for adjournment.
That will be a bit troublesome for me in the sense that the next week I'll not be here.
Yes,
And,
what do you want?
Today we have filed our Wakalatnama, Lordship. I would like the matter may be fixed on Monday, Lordship.
No,
This
Monday only my problem is I'll be away from here.
Tomorrow then, sir.
Tomorrow, yes,
Tomorrow.
no problem, tomorrow. Yes. No,
Okay.
Tomorrow, please. Huh?
Heard Mr. S. Dutta, Learned Senior Counsel assisted by Miss S. Mushari, Learned Counsel for the petitioner. Also heard Miss
Cabral.
K. Bharali, who submits that she would be appearing for all the respondents, and Wakalatnama has been filed by them today only. She prays for an adjournment for 1 day only, to which Learned Senior Counsel for the petitioner does not raise any objection. Let this matter be listed again tomorrow.
Bless.
Item 18.
Yeah, please, Your Lordship. Let
Yes.
the appellant start. My senior will come.
Who is your senior?
Arthur. She's having another hearing matter at court number 19, Lordship. Both fixed at 2 p.m. Let the appellant start. She will come eventually.
Yes. How long, how much time will you?
40 minutes, 40, 50.
Take half an hour.
Hello.
Take half an hour.
I shall try.
Yes.
My lord, first I am saying the story of the case
Yes.
in nutshell.
No, before you tell me your story, let us see the substantial question of law.
Next one,
Substantial question of law,
substantial question of law.
which was framed on which date? By which order substantial question was framed?
Yes, substantial question of law, my lord. It was formulated on 10/1/22.
10/1/22.
Whether the learned courts below were justified in rejecting the prayer of the appellants to produce two registered cell leads. But cell lead number so and so, that is so and so, and cell lead number so and so, that is so and so, of sub-register office, which can be the subject matter of partition for other legal heirs of the seller, late Kamoruddin, that is the respondents. The appellant shall have the liberty to raise any other substantial questions of law at the time of hearing. Now, my lord, case was this like, parties are own relatives, brothers, and brother's son. Here, 7 biga plus 1 biga of land, 1 biga to 1 biga, my lord, one biga, 4 kata, 8 lessa. Those are the donated land. 7 biga land was purchased
By whom?
by the present appellants from Mohirun Nessa. Late Mohirun Nessa, this Maqbul Hussain purchased, Maqbul Hussain and his brother Afzal Hussain. The two appellants purchased 7 bigas of land by registered sale deed.
Okay.
By registered sale deed. And besides this, my lord, some land was donated to this Kamoruddin donated some plot of land to the present appellants. The total, they would get nearly 10 bigas of land. Surprisingly, in between this purchased plot of land, that is measuring 7 biga. 7 biga of land. Lordship may kindly see page 76, 77 and 36. First kindly see page 36.
No, you tell me the story first. What?
Story is
In
like
nutshell, both the appellants purchased 7 bigas of land.
yes.
Then one may,
And some land was
some lady donated you
donated.
3 bigas. So
Yes.
total 10 bigas.
10 bigas.
Then what happened?
Now, these 7 biga plus 3 biga lands have been also made subject matter of partition in the present suit. So, the land which I have purchased from Mohirun Nessa was donated this plot of land by her husband, kindly see, Mohirun Nessa Shami Shahabuddin. So, Shahabuddin sold some plot of land to Mohirun Nessa. That lordship may kindly see, cell deed, we have registered cell deed. But we are bound to give this this deeds to your lordship, because my lord, the learned court below, we filed petition that the documents we want to prove, because the persons who were the attested witness of the cell deeds, they were not there. So we filed petition before the learned court below, trial court, that these two documents which are available in the sub-registrar office at Bijni, those documents should be allowed to be brought on record, so that we may prove the same through an officer of the sub-registrar office. But that was rejected. That was rejected. Now, order, now lordship would see here, order 11, can you see?
Yes, order 11.
Order 11, rule 12, 14 and 16. 12, application for discovery of documents, any party may, without
No.
filing
When
any.
your prayer was rejected
Rejected.
to bring on
The-
record the
the-
sale deeds.
Cell deeds.
That
was rejected.
Whether you challenge that rejection order,
At that time, we did not challenge.
then matter ends there.
No matter ends there, my lord, how the matter, it is law point. Law point may be raised even in the Supreme Court.
But you could have agitated that rejection order.
Yes, that could have been agitated by your filing CRP-IO. We could do it, but that was not done. But party should be given fullest opportunity to prove his case. My lord, kindly would consider the party should be given fullest opportunity to prove his case, his or her case. Now, order 11, rule 12 says application for discovery of documents. Now, kindly see 14, rule 14. Production of documents, it shall be lawful for the court at any time. Kindly see. Now, at any time during the pendency of any suit, to order the production by any party thereto upon oath of such of the documents in his possession or power relating to any matter in question in such suit as the court shall think right, and the court may deal with such documents when produced in such manner as shall appear just. Now, lordship may kindly see rule 16. Notice to any party to produce any documents referred to in his pleading or affidavit shall be in Form 7 in Appendix C with such variations as circumstances may require. Here, my lord, order 15 says that the inspection of documents referred to in pleadings or affidavits. Every party to a suit shall be entitled at or before the settlement of issues to give notice to any other party in whose pleadings or affidavits reference is made to any document or who has entered any document in any list annexed to his pleadings or produced such document for the inspection of the party giving such notice or of his pleader, and to permit him or them to take copies thereof, and any party not complying with such notice shall not afterwards be at liberty to put any such document in evidence on his behalf in such suits unless he shall satisfy the court that such document relates to only to his own title, he being a defendant to the suit or that he has some other cause or excuse which the court shall deem sufficient for not complying with such notice, in which case the court may allow the same to be put in evidence on such terms as to cost and otherwise as the case court shall think it. Well, I have put some documents in this regard. Now, my submission is this, yes. At the time when the learned trial court rejected their petition, they could have come. But there was an appeal. The appellate court was the court of facts as well as law. So here, the first appellate court also do this in the interest of justice. That was not done. Now in second appeal, only the question of law will come. Now law says that any party may send a notice to the concerned party in whose possession the document is there to produce the same in order to prove or disprove the case. So here our petition was rejected. Let me show your lordship the relevant portion of the notice. First, lordship, kindly see page 36. Para 12. That the statements made in para 3 of the plaintiff is partly admitted and partly denied by the defendants. It is admitted by the defendants that late Shahabuddin Mia and late Komaruddin were joint owners and possessors of 41 Biga 1 Kata 5 Lesa covered by Patta number 185, Dag number so and so, situated at village Noyagaon under Bijni Revenue Circle. Shahabuddin was issueless. So he brought up his nephew named Ismail Mia, son of late Shamajuddin, and called as his foster son of the said Shahabuddin. And Shahabuddin, out of love and affection to his foster son, that is Ismail Ali, gave him 5 biga land out of a scheduled land. During the lifetime of Shahabuddin, he sold the 5 biga 2 Katha 17 Lesa 5 number so and so, Pata number so and so, 1 biga 2 Katha 3 Lesa by Dag number so and so, total land 7 biga on dated 30/12/1966 by Register Sally to his wife, that is Mohiran Nessa. So Mohiran Nessa was given, that means was sold to her total 7 bigas of land by Register Sally, lordship. Here this is very important thing, Register Sally. And thereafter, kindly see, why Mohiran Nessa out of a scheduled land and delivered the possession of the said land in favor of Bhendi Mohiran Nessa. So this 7 bigas of land was not only sold to her, but it was also delivered to her. The plaintiffs are suppressing the material facts in respect of sale of land by Shahabuddin in favor of Mohiran Nessa, rest allegation. Now, lordship may kindly see, let us see now page 76. Lordship, here one important thing is this. From this Mohiran Nessa, we purchased 7 bigas of land, which was sold to Mohiran Nessa, and Mohiran Nessa obtained the possession. And from Mohiran Nessa, we have purchased. So how this is the self-acquired property? How this plot of land can be the subject matter of partition? This is the vital issue. That's why the Honorable High Court at the time of framing the substantial issue, that question was there, whether this 7 bigas of land which was purchased by present to appellants from Mohideen Nessa can be the subject matter of partition. Because during their lifetime, they sold this land to Mohideen Nessa and it is admitted. But the deed is there, but that is, I have given the copies of deed. Deed is there. But original deed they had not, that's why they wanted to have the same from the sub-register office. Sub-register office would have sent the document, whether that is a document or not. So that is one very important aspect, who is the learned courts below, totally forgot. Second thing is this, my lord. Very important thing is this. These two cell deeds are not set aside. This cell deed, two cell deeds, that means by one cell deed, Mohideen Nessa was sold the land, and by another deed, this appellants purchased this land. Lordship, as far as I am clear, first thing, Mohideen Nessa purchased this plot of land
From Shahabuddin.
from Shahabuddin and got delivery of possession. Thereafter, she sold this plot of land to present appellants. And both these deeds are not set aside. These are registered sell deed. If a registered sell deed is not given any value,
You were the defendant in the suit.
my lord,
You were the defendant.
yes.
The suit was for partition.
So how this plot of land? And the judgment is perverse, my lord, because the sell deeds were not set aside. When the sell deeds were not set aside, it remain intact. Sell deed, lordship is aware about that. The sale takes place when some consideration is paid, delivery of possession. So registered sell deed followed by delivery of possession. So in both the cases, still the land is in our possession, my lord. Still. So these two sell deeds were not cancelled. Now, lordship may kindly come to page 76. 76.
Yes.
Sorry, madam. Before that, lordship may kindly come to page 58. 58. Defendant, 58, issue number 2, 3, 4, and 5. Defendant pleaded that Mohideen Nessa has transferred 7 bighas of land in favor of defendant number 2 and 3. In this context, learned counsel of the plaintiff submitted that defendant have not mentioned and failed to submit the deed to or instruments by which says 7 bighas of land was transferred to Mohideen Nessa, and like defendant also failed to mention the nature and feature of the instrument by which defendant number 1 and 2 got aforesaid 7 bighas of land by way of transfer from Mohideen Nessa. In this context, learned counsel of the defendant submitted that though defendant prayed, lordship here, prayed, we have prayed before the court to enlist the registered sell deed in the name of Mohideen Nessa and sell deed and registered sell deed in the name of defendant number 1 and 2, but the same was rejected on the ground that the said documents were produced before the court at the not produced before the court at the appropriate time. Hence, learned counsel of the defendant prayed to take those documents in judicial notice. But in my opinion, if I take those documents into my judicial notice, the whole nature of the suit may be changed without giving any opportunity to other side. My lord, here very objectionable finding. very objectionable finding of the learned court below. What he says, if I take those documents into my judicial notice, the whole nature of the suit may be changed. May be changed. So what? If the documents is saying something and the nature of the suit is changing, the learned magistrate may give them a chance to defend their case. But the learned magistrate says that if I accept this, the nature of the whole case would be changed. So what? Totally wrong conception, madam. So what? Let the nature of the suit be changed because it is registered deed. So here, at appropriate time, my lord, I admit, at appropriate time, petition was not filed or documents were not filed. But it is said that at any time before pronouncement of judgment, in the interest of justice, the document can be produced. Only notice will go to the sub-registrar that you come along with deed number, so and so, if in your office, he will come and say. But that chance was not given to me.
No, whether you prayed for, whether you filed any application for production.
Yes, it is spread for application. I have not annexed, perhaps a record may be there, but here it is spread for. So prayed means it may be oral or written, but so my defendant, kindly see the word. The learned counsel of the defendant submitted that though defendant prayed before the court to enlist the registered cell deed in the name of Mohirun Nessa and cell deed of registered cell deed in the name of defendant number 1, 2, but the same was rejected.
What is the meaning of enlisting the registered sale deed?
To register cell deed.
No, while you file your written statement.
Yes. Yes, I have in written statement that is
Along
there.
with this written statement.
Yes,
Whether
that is there, madam.
Have you-
Written statement, lordship may kindly see, page 35.
Certificate is the written statement.
Page 35, kindly see, operative portion, page 36, 12, para 12. Onwards. 12, I am reading. The statement made
No,
in the.
you made statement that this was sold by Shahabuddin to Mahirun Nessa. You made that statement. But in support of your statement, whether you annex the sale deed, you did not annex any sale deed.
We did not annex, but my lord, it is numbered. Even when number has been given, the learned court has also given the number.
Thereafter, did you made any application for production of sale deed?
That is, my lord, may I see the record for some time? LCR. Kindly allow me to see the LCR for the time.
Then you go through the, yes, what is your stand?
While they have adduced the evidence as DW1, they have
My
mentioned
submission
number of
is not yet.
No, no, I'm just,
only.
I'll come back to you.
Clarifying that part only.
Yes,
Clarifying only that part. At the time of adducing evidence of DW1, they have submitted number of documents, lordship, as exhibit A, B, C, D. But those were not submitted before the court. Only it was written in the DW1. For that only the court rejected their prayer.
they did not adduce these sale deed,
Documents.
these documents.
Only it is mentioned in the DW1 that there are some exhibits, lordship.
But it was not exhibited.
Exhibit A, B, C, D, E, F, G, H, I, J, K, L. Sale deed, gift deed, everything was mentioned in the evidence in chief. But court held that those were not submitted before the court, so their sale deeds were rejected. So there.
Sale deeds were not before the court.
No, lordship. Though they have
And
exhibited
with-
the documents, they ought to have annexed those documents along with their DW1, either with WS
or with DW1, but they have not annexed the documents but written in the DW1. So that was rejected by the learned trial court. They have not preferred any civil revision. So it
And,
attained finality.
okay, and in the appellate court,
No
any
order
prayer for
41
order 41 rule 27?
No, Lordship, even before this court also, there is no order 41 rule 27 petition.
Yes, Mr. Mahmood. You go through the,
Well, here one petition I see, whether it is in record or not.
no, I would suggest,
No, in the order sheet 5/10/2010, defendant filed petition 150
Yeah.
for accepting documents, rejected 29/6/11. No challenge to that order, Lordship. Plaintiff filed one petition for cross of remaining PWs, rejected, hence PW 5 was not cross-examined. Both those orders attain finality. In our orders
Okay.
also, Lordship, attain finality.
let him complete his submission.
Lordship.
Now it is clear that we file petition.
Which petition?
We file petition to produce the document. Here, it is says that number is given, kindly see. Uparokta number Gosarar Huzur
On which
Adalat,
date you filed petition?
that, my lord, that
Petition under what provision?
10/10/2009. 10/10/2009, like
In this petition, it is written as 2010/2009.
2010.
Assam is a-
2010.
Petition under what provision?
Provision is not given. Provision is not given, but Lordship is our High Court said that
Adhibhoktar Prarthana, Lordship.
not mentioning of proper section would not defeat the ends of justice because,
Nothing would defeat the ends of justice, but that is required under law.
of course, that I admit. But what is in record, I cannot go beyond record. So actually, this is the mistake of the perhaps learned counsel who conducted the case.
What happened? What was the petition? 10/10/2020.
Petition's main thing was that the business circular অন্তর্গত নয়াপাড়া গাঁৱৰ মাটি বুলি আগতে উল্লেখ কৰিছো যাৰ পট্টা নম্বৰ 185 that means present land দাগ নম্বৰ 678-708-866-883 the same land madam নাই গছৰ উল্লেখ আছে বিবাদী জমি মহামান্য আদালতত একতাৰৰ বাহিৰত এই বাদীগণে এই আদালত বিচাৰে that means well there are two actually. Another thing, my lord,
This petition is not for production of documents.
Territorial jurisdiction, Lordship.
that
That point was raised by the defendant on 8/12/2000.
that means, my lord, here is another thing. One land falls within Srijangam circle, and another plot of land falls Manikpur circle. And both the lands have been the subject matter have been made subject matter of this suit. But this Srijangam falls within Abhayapuri court and this Manikpur falls within formerly at Bijli, now at Bongaigaon court. So two plots are situated in two different places. Now, yes, that is, I remember one judgment that even the two plots of the same person maybe also be made the subject matter of one suit, but courts must state the reason. Court must state the reason as to why the land of Manikpur and land of Abhayapuri have been merged together in the common suit. Court must state the reason. But in the present case, I do not see that. No reason is given why the two jurisdictions, courts, lands have been made as the subject matter of one suit.
No, but that is not the question before this court. You have not pleaded that this regular second appeal is on a different substantial question.
I understand, but
So we have to confine ourselves to the,
yes, Lordship is correct, but thing is this, the substantial question is still there. Order 11, rule 14, 15, 16 is very much clear that if any petition is filed, or not only petition, my lord, sometimes even the oral submission also may be accepted by the court. There is no bar. Even in there are some cases, Supreme Court has said, in some cases, even the lawyer can also settle the case. There is Lordship is aware about that. But here it is very much clear that we prayed to produce the document. Why, my lord? Lordship is saying, my learned friend has said it is not exhibited. Yes, as it is not exhibited, so it should not be taken. But thing is this, why I could not exhibit? Because my prayer was rejected
by which order?
by the court order. It is just now I have read, court has rejected. That is page 76, perhaps.
No, page 76 is the observation that why it cannot be taken into consideration. But your prayer for production of documents under order 11 rule 16, when it was rejected, by which order it was rejected?
78, Lordship. Paragraph 17, rejection of the documents.
Page 76 onwards, right?
78 to 17 paragraph.
78. 76. Here, my lord, page 74, my lordship may kindly say, page 74 bottom.
74 is the appellate court's judgment, impugned judgment. First appellate court's judgment.
Even then, my lord, regarding gift, Mohammedan law, that is Mohammedan law, as the parties are Muslims, so Mohammedan law, oral gift is also admissible. That is section 136, 147, my lord. I am reading.
No, that is accepted.
Yes. That is accepted, and the witnesses have also adduced here that there was a gift, gifted with delivery of possession. The essentials of gift, my lord, 3. The essentials of gift is 3. 3 conditions must be fulfilled. First thing, declaration by the donor. Second, acceptance by the donee. And thirdly, delivery of possession. So here, regarding the portion of the land which has been donated, these 3 conditions are fulfilled. Am I clear, my lord?
Where is that?
Yes.
Where is the evidence?
Evidence is there, man. Evidence, but no.
Or where is the observation of the trial court or the appellate court as regards gift of 3 bighas?
$59, Lordship may kindly say 59.
Yes. Para
Para is not given, but
First, second, third, fourth.
yes, second it will. Learned counsel of the plaintiff also submitted that defendant has failed to prove the oral gift as it claimed that late Komaruddin made a oral gift of 3 bigha, 3 gatha, 19 lesa of land in favor of defendant number 1 and 2. Further, it is submitted that in order to create a oral gift, according to Mohammedan law, at least 2 witnesses are required. But defendant have failed to prove the aforesaid oral gift. I have gone through the evidence of defendants and found that defendant's witnesses has failed to prove the fact of oral gift as required by law to prove. My lord, this observation is wrong because 3 witnesses have given the evidence that gift is there and it is delivered to them because the donor had no son. He brought this Komaruddin.
No, the observation of the trial court
Observation.
in the judgment is that you failed to prove the oral gift.
Oral gift. But this observation is not correct. Well,
Show me how it is not correct.
yes,
Where
then we shall have to go to evidence.
Yes,
And Lordship is aware, evidence, wrong reading of evidence or misreading of evidence is also a substantial question of law. Perhaps Lordship is aware about that?
yes. Show me where 2
Yes.
witnesses.
Wrong reading and misreading. That is also substantial question of law. Now let me see the evidence part.
No, whether this question was raised before first appellate court regarding gift.
So read that.
What first appellate court held regarding gift? What was the
That
observation?
Lordship may kindly see page 69 onwards, 69 onwards.
Where is the discussion on
Yes,
the gift?
I am coming back.
It also held that no witness was examined to prove the gift.
Page 76, Lordship kindly see.
76, para 11.
11, yes. Issues 2, 3, 4, and 5. These issues were considered together for decision by the learned.
So both the courts held that no witnesses of the oral gift were there.
No.
You show me
Yes.
that there were.
So I will show that. I will show that. Man. I will show here witness number 2, Taramia.
C1 file. Original recorder. लिखा था कि बस C1. Yes.
Lordship, after 10 lines, Lordship may kindly see. অর্থাৎ শাহাবুদ্দিনের মৃত্যুর আগতেই Lordship has seen Taramia, he is witness number 2 of the defendant side. শাহাবুদ্দিনের মৃত্যুর আগতেই, that means before his death, শাহাবুদ্দিনের মৃত্যুর আগতেই অর্থাৎ জীবিত অবস্থায় ইসমাইল মিয়া ক তফসিল জমিৰ পৰা 5 বিঘা জমি দান দিয়ে ও লগতে দখল বুজাই দিয়ে শাহাবুদ্দিনে তেওঁৰ জীৱিত কালত তেওঁৰ স্ত্ৰী মহিৰুন নেছাক ক তফসিল জমিৰ পৰা 5 বিঘা 2 কাঠা 17 লেচা যাৰ দাগ নম্বৰ 708 পাট্টা নম্বৰ 185 আৰু
Where are you reading? PW2.
DW2 Taramia. Here, regarding the gift as well as sell, both things are, he has adduced the evidence.
What was the cross?
Cross. This, regarding this sell and this gift, repeatedly he has said, so far regarding cross,
When the gift was made, on which date?
kindly now cross part is this. Badi Alaluddin and Jalaluddin more একো নহয় এই বিবাদে মাটি বটৱাৰাৰ সময়ত আহাদুল্লাহ কুরবান আলী মহেশ দেৱানী আছিল ভাগ বটৰা তাৰিখ মোৰ মনত নাই কোনো লিখিত ভাগ বটৰা হোৱা নাই Lordship is aware that family settlement may not be in writing 28 বিঘা মাটিৰ ভাগ বটৰা হৈছিল 28 বিঘা মাটিৰ ভাগ বটৱাৰা কমৰুদ্দিনৰ ল'ৰা ছোৱালীৰ মাজত হৈছিল তেখেতৰ দুইজনী পত্নী আছিল তেওঁৰ সৰ্বমুঠ 4 জন ল'ৰা আৰু 4 জনী ছোৱালী আছিল তেওঁৰ প্ৰত্যেকজনী ছোৱালীক 1 বিঘাকৈ মাটি দিয়া হৈছিল আৰু প্ৰত্যেকজন ল'ৰাক 6 বিঘাকৈ মাটি দিয়া হৈছিল 6 বিঘাকৈ দিয়া হৈছিল কমৰুদ্দিন আৰু শাহাবুদ্দিন দুই ভাই আছিল তেওঁলোকৰ 41 বিঘা 1 কাঠা 5 চছা মাটি আছিল উক্ত 41 বিঘা 1 কাঠা 5 চছা মাটি নয়াগাঁৱত আছিল আৰু এটা দাগত আছিল শাহাবুদ্দিনৰ কোনো ল'ৰা ছোৱালী নাছিল শাহাবুদ্দিন অনুমান 1970-75 চনত মৰিছিল তেওঁ মৰাৰ পিছত তেওঁৰ পৰিবাৰো মৰিছিল তেওঁৰ নাম আছিল মহিৰুন নেছা শাহাবুদ্দিন মৰাৰ আগতে তেওঁৰ পৰিবাৰক 7 বিঘা মাটি ৰেজিষ্টাৰ দলিল যোগে দিছিল This is very important thing.
No. This is an oral statement. Read further.
আৰু দলিল সম্পাদন কৰা হৈছিল কোকৰাঝাৰত শাহাবুদ্দিনে তেওঁৰ পৰিবাৰক দান নে বিক্ৰী দলিল কৰি দিছিল মই ক'ব নোৱাৰো দলিল সম্পাদন কৰাৰ দিনা মই কোকৰাঝাৰত যোৱা নাছিলো শাহাবুদ্দিন
Now this statement that whether it was gifted or it was a sale, I don't know. How he can be a witness of gift?
That is regarding gift, that is another thing. But regarding registered sale deed,
No, we are now on the question of gift. We'll come to registered sale deed later on. Both the court, trial court and appellate court held that the defendant failed to prove the gift by adducing witnesses, two witnesses.
আৰু উক্ত 3 বিঘা 2 কাঠা 10 চছা মাটি 1 আৰু 2 নম্বৰ বিবাদীৰ দখলত আছে 1 আৰু 2 নম্বৰ বিবাদীৰ বৰাবৰে মহিৰুন নেছে বিক্ৰী কৰা মাটি ভাগ বটৰা হোৱা নাই সত্য নহয় আলালুদ্দিন আৰু জালালৰ 6 বিঘা মাটি দিয়া নাছিল মকবুল আৰু আফজাল কমৰুদ্দিনৰ ডাঙৰ ল'ৰা আৰু তেওঁৰ প্ৰথম পৰিবাৰৰ ল'ৰা মোৰ সাক্ষাৎ শাহাবুদ্দিন মৰাৰ আগতে তেওঁৰ পৰিবাৰক 7 বিঘা ৰেজিষ্টাৰ দলিল যোগে দিছিল বুলি কৈছো যদি দলিল নম্বৰ উল্লেখ কৰা নাই দলিল নম্বৰ it is not possible to keep in memory সত্য নহয় কমৰুদ্দিনৰ উত্তৰাধিকাৰৰ মাজত ভাগ বটৰা শৰীয়তৰ বিধান মতে হোৱা নাই আৰু 1 আৰু 1 নম্বৰ বিবাদীয়ে বেছি মাটি দখল কৰি আছে now regarding Mokbul's cross value Mokbul's cross regarding here
DW3.
He is DW I think he will be DW1 Here Lordship would see, kindly see his cross. নয়াগাঁৱত 708 নম্বৰ দাগত 30 বিঘা 3 কাঠা 15 লেচা মাটি আছে। উক্ত মাটিৰ উত্তৰে ওয়াজউদ্দিন, দক্ষিণে তালেবালি, পূবে জলিল, পশ্চিমে গোহালত রাস্তা। নয়াগাঁৱৰ 6টা দাগত 35.5 বিঘা মাটি আছে। এই নয়াগাঁৱৰ মাটি মই আফজল হুছেইন, ইছমাইল, জালালউদ্দিন, আলালউদ্দিন, কদভানু বেৱা, আইমন খাতুন, রমেলা খাতুন, মনোয়ারা খাতুন, কমলা খাতুনে হক দখল কৰি খাই আছে। জালালউদ্দিনে 6 বিঘা মাটি হক দখল কৰি আছে। আলালউদ্দিনে 6 বিঘা, কদভানুৱে 1 বিঘা মাটি 1 বিঘা 4 কাঠা আৰু ইছমাইলে 5 বিঘা মাটি ভোগ দখল কৰি আছে। বিভেদ মাটিৰ বাদী বিবাদীৰ মাজত ভাগ বতৰা হৈছিল মৌখিকে। বিভেদ মাটি আগতে কামৰুদ্দিন আৰু শাহাবুদ্দিনৰ আছিল। শাহাবুদ্দিনৰ কোনো সন্তান নাছিল। কমৰুদ্দিন আৰু শাহাবুদ্দিন 35-33 বছৰ আগতে মৃত্যু হৈছে। শাহাবুদ্দিন আগতে মৃত্যু হৈছে। Further cross reserve. Then he comes next cross example. শাহাবুদ্দিন আৰু কমৰুদ্দিনে দুজন আপন ভাই ককাই আছিল। প্ৰথমতে শাহাবুদ্দিন ঢুকাই, তাৰপিছত কমৰুদ্দিনৰ মৃত্যু হয়। He is a natural witness. He knows everything. শাহাবুদ্দিনৰ পৰিবাৰ মহিৰুন নেছাৰৰ মৃত্যু হৈছে। শাহাবুদ্দিনৰ কোনো সন্তান নাছিল। ইছমাইল মিয়া এলিয়াছ হুছেইন শাহাবুদ্দিনৰ পালনীয় সন্তান আছিল। শাহাবুদ্দিনৰ জীবিত অৱস্থাত ইছমাইল মিয়া 5 বিঘা মাটি দান পত্ৰ কৰি দিয়ে। শাহাবুদ্দিন আৰু কমৰুদ্দিনৰ দুজনৰ নামত বিজনেছ চাৰ্কলৰ আণ্ডাৰত নয়াগাঁৱত আৰু সিজনগাঁও চাৰ্কল আণ্ডাৰ নাম্বাৰপাৰা গাঁৱৰ মুঠ 45 বিঘা 5 কঠা 5 লেচা জমি আছিল। নাম্বাৰপাৰা গাঁও 3 বিঘা 2 কাঠা 10 লেচা আৰু কুকিলা আৰু বাকী নয়াগাঁৱৰ 10 লেচা আছিল আৰু নয়াগাঁৱৰ আছিল। নয়াগাঁৱৰ পৰা শাহাবুদ্দিন আৰু ইছমাইল হুছেইনৰ নামত 5 বিঘা জমি দান পত্ৰ কৰি দিয়ে। শাহাবুদ্দিনে গাঁৱৰ বাকী থকা মাটিৰ পৰা 7 বিঘা মহিৰুন নেছাৰ নামত ৰেজিষ্টাৰ দলিল কৰি বিক্ৰী কৰি দিয়ে। কোন তাৰিখত সেই মাটি বিক্ৰী কৰে ক'ব নোৱাৰো, দলিল নম্বৰ ক'ব নোৱাৰো। বিক্ৰী দলিলৰ সাক্ষী মফিজুদ্দিন আৰু আব্দুল হুছেইন আছিল। সেই সময়ত মোৰ বয়স 65-66 মান হ'ব। বৰ্তমান মোৰ বয়স 69-70 মান হৈছে। মই বৰ্তমান ব্যৱসায় কৰোঁ। আগতে খেতি কৰিছিলোঁ। শাহাবুদ্দিন আজিৰ পৰা 42 বছৰ আগত মৃত্যু হৈছে। শাহাবুদ্দিন আৰু কমৰুদ্দিনৰ জীবিত অৱস্থাত পৃথককৈ খাইছিলে। শাহাবুদ্দিনে মহিৰুন নেছাক ৰেজিষ্টাৰ দলিল কৰি দিয়াৰ সময়ত মই ৰেজিষ্টাৰ অফিচলৈ অহা নাছিলোঁ। সত্য নহয় যে শাহাবুদ্দিনে মহিৰুন নেছাক 7 বিঘা মাটি বিক্ৰী কৰা নাছিল। সত্য নহয় যে মহিৰুন নেছা শাহাবুদ্দিনৰ ৰেজিষ্টাৰ দলিল যোগে কিনা 7 বিঘা মাটিৰ দলিল আদালতত দাখিল দিয়া নাই। কমৰুদ্দিনে বাকী মাটিৰ মালিক। নাম্বাৰপাৰা গাঁও আৰু নয়াগাঁও মুঠ জমি 41 বিঘা 1 কঠা 5 লেচা জমিৰ পট্টা নম্বৰ 185। মুঠ মাটি 6টা দাগত অন্তৰ্ভুক্ত আছিল। দাগ নম্বৰবোৰ ক'ব নোৱাৰো। ইছমাইল মিয়াক কোন দাগৰ পৰা 5 বিঘা মাটি দিছে ক'ব নোৱাৰো। মহিৰুনক কোন দাগৰ পৰা মাটি দিয়া হৈছে মোৰ মনত নাই। মহিৰুন নেছাৰ 7 বিঘা মাটি মোৰ আৰু মোৰ ভাই আফজল হুছেইনৰ নামত দান কৰি ৰেজিষ্টাৰ কৰি দিছে নে বিক্ৰী কৰি ৰেজিষ্টাৰ কৰি দিছে মনত নাই। কিমান তাৰিখত ৰেজিষ্টাৰ দলিল কৰা হৈছিল মনত নাই? মহিৰুন নেছাই মোৰ আৰু আফজাল হুছেইনৰ নামত এখন দলিল যোগে ৰেজিষ্টাৰ কৰে। সেই দলিলৰ নম্বৰ আৰু তাৰিখ মনত নাই? সেই দলিলৰ সাক্ষী আছিল আব্দুল জলিল, দলিল কোন মহৰীয়ে লিখে মনত নাই? এই দলিল কৰা 4-5 বছৰ পিছত মহিৰুন নেছাৰ মৃত্যু হয়। মহিৰুন নেছা কোন তাৰিখে মৃত্যু হয় ক'ব নোৱাৰো। মহিৰুন নেছাই আমাৰ নামত মাটি ট্ৰান্সফাৰ কৰাৰ পিছত আমি 2 ভাইয়ে সেই মাটি ভোগ দখল কৰি খাই আছো। সত্য নহয় যে মহিৰুন নেছাৰ পৰা আমি মাটি আমাৰ নামত ৰেজিষ্টাৰ কৰা দলিলখন আদালতত দাখিল দিয়া নাই আৰু প্ৰমাণ কৰা নাই। কমৰুদ্দিন ও 2জন পৰিবাৰ আছিল। প্ৰথম পৰিবাৰৰ নাম সবজান নেছা। সবজান নেছাৰ মৃত্যুৰ পিছত কমৰুদ্দিনে কদভানু নেছাক বিয়া কৰে। কমৰুদ্দিনৰ প্ৰথম পৰিবাৰৰ পৰা 5টা ল'ৰা ছোৱালী হয়। তাৰে 3জনী ছোৱালী আমিনা, ৰহিমা আৰু মনোৱাৰা আৰু 2জন ল'ৰা মকবুল হুছেইন আৰু আফজাল হুছেইন হয়। কদভানু নেছাৰ পৰা কমৰুদ্দিনৰ 2জন ল'ৰা জালালুদ্দিন আৰু আলালুদ্দিন আৰু ছোৱালী কমলা খাতুন কদভানু বৰ্তমানো জীৱিত আছে। উক্ত ৱাৰিছগণৰ বাহিৰে কমৰুদ্দিনৰ আৰু কোনো ৱাৰিছ নাই। সত্য নহয় যে মহিৰুন নেছাই মোৰ আজিজুল হুছেইনৰ নামত কোনো মাটি ৰেজিষ্টাৰ দলিল কৰি দিয়া নাই। বিবাদীয় মাটি ভাগ বতৰা হয় কেতিয়া তাৰিখ মনত নাই। ভাগ বতৰা মৌখিকভাৱে হয় আৰু ভাগ বতৰা জালালুদ্দিনৰ ঘৰত বহি হৈছিল। ভাগ বতৰাৰ সময়ত 10-12 জন মানুহ উপস্থিত আছিল। ৰমজান আলী, আমজাদ আলী, জাহেৰ আলী, তাৰা মিয়া, গনি মিয়া. Tara Miya is the witness here, my lord. He is the witness, DW2. Tara Miya, Goni Miya, Ismail Hussain and Abdul Jalil, Shujat Ali, Faizuddin, Muhammad Ali আৰু ভাগবতৰাৰ সময়ত উপস্থিত আছিল। তাৰা মিয়া মোৰ গাঁৱৰ সম্বন্ধীয় ভিনী, সাক্ষী আব্দুল গনি মোৰ ল'ৰা। সত্য
The gift in this case was made by is it an oral gift deed? Oral gift or
Oral.
But you have produced a registered copy of registered gift deed. These 2 deeds.
The court has said it's oral gift. That's
No, but what is your stand?
I have court verdict. Court said that oral gift. But
The court said that you failed to prove the gift.
no, that is my question before your lordship. Why court will say? Court will say on the basis of document. Court's finding should be on the basis of document.
Court finding is that you failed to prove the gift.
But how document can be proved? Section 67, my lord, of the Evidence Act. If a person says, yes, this is this plot of land.
You did not exhibited the gift deed. For proving the document has to be brought before the court.
So for gift deed, my lord, there is no petition that it was called for. If it is registered, it is called for.
These 2 photocopies which you have produced today, what are these? One is a gift deed, another is
No,
this.
it is registered sell deed. Sell
Both?
deed and give both 2 gifts, 2 deeds I have given.
Both are sale deeds.
No, one perhaps one is sell deed, another is gift deed. No, one is sell deed. It is sold by to Mohirun Nessa, and another is sold by Mohirun Nessa to present appellants. two deeds are there. One lordship here, lordship would say,
You check that.
Mohiran Nessa.
What?
Mohiran Nessa, Shahabuddin sold to Mohiran Nessa.
You check the deeds. Show it to the other. You have a copy of these deeds.
I have the certified copy, Lordship. Lordship, their case is that Sahabuddin was issueless, so he upbringing one Ismail Ali, Lordship. 5 bigha registered gift deed to Ismail Ali. And another plea is that, Lordship, one oral gift in favor of defendant number 1 and 2 by Shahabuddin.
By Shahabuddin.
By Shahabuddin.
3
And another-
bighas.
And to Ismail, 5 bigha registered gift deed.
Okay.
Foster son, Lordship. And to defendant number 1 and 2, another oral gift deed and registered sale deed in his wife's name, Mohiran Nessa. And Mohiran Nessa again sold the same plot of 7 bigha of land to defendant number 1 and 2.
That is
So
their
2
case.
registered sale deed, 1 registered gift deed in the name of foster son and 1 oral gift deed. That is their pleading, Lordship, in the written statement.
Here, my lord, what these two documents I have given your lordship. First one is Shahabuddin. Shahabuddin executed deed, registered deed in favor of his wife, Mohiran Nessa.
Sale deed.
Sell it. Register sale.
7 bighas.
7 big.
Okay.
And the second one is the present appellants, Mokbul Hussain and Jalal Hussain. So these two persons purchased these 7 bighas of land from Mohiran Nessa, followed by delivery of possession. Now, my lord, my case is only this, my lord. How this plot of land can be the subject matter of partition. Now, my learned friend may say that I could not prove the documents. I could not prove these two documents that Mohiran Nessa was sold by her husband and from Mohiran Nessa we have purchased. We could not prove. Now, we could not prove because court did not allow us to bring the document from the concerned registered survey. Earlier it was in Kokrajhar, now at Bijni. So, kindly see, why court should not allow? Yes, I have not prayed at appropriate time. Well, this is a civil case. I have not prayed for at the appropriate time. Further, some cost may be imposed. But whether for that,
By which order court rejected your prayer?
yes, that is, my lord, I have said. And the court said that he could not prove. He could not prove
No, that is the observation made in the judgment.
in the,
But prior to that, whether court rejected your prayer,
yes, rejected my prayer.
where? By which order?
Yes, 50 onwards.
Page?
50 onwards. Let me show.
No, 50 is the.
Onward, I might not. I
No,
will read onward, thereafter.
what is this 50? Is it the judgment of the trial court?
Written statement.
It
page
is written
50.
statement. My query
No,
is,
there are written statement is page 35.
no, my query is, you are saying that you were not allowed to produce the document. Court rejected your prayer. By which order it was rejected? There must be some order of the court.
So
Re-
29-6,
For a
11.
moment, may I see the
29-6?
LCR,
11.
my lord.
It is there in the LCR, Lordship. 5, 10, 10, they have filed one petition, petition number.
Order sheet some for A1. First file.
Territorial point
No,
was,
you don't know my title suit.
territorial point was rejected on Lordship 8/12/2009.
Territorial, we have not given so much
No,
importance.
that production of document, it was rejected on
29/6/11.
when the parties are represented by so and so. By this order, the prayer was rejected. It's a long order.
Two petitions were rejected, one from the plaintiff side, one from the defendant side. So our PW5 was not cross-examined.
And what was the prayer for defendant?
I have written a note from LCR that 5/10/10 defendant filed petition 150 for accepting documents, rejected 29/6/11. Plaintiff filed 1501, petition number 1501.
1501, that is under order 1 rule 1A.
For accepting documents, Lordship.
In my humble opinion, my lord, this is a fit case, according to me, to remand the case. Because how the purchase self-acquired property can be the subject matter of partition among the legal heirs. How? It is registered document. Now it is not proved, but it was not allowed us to prove the document. Of course, it is admitted we have filed a petition late.
And you have not challenged this order dated.
That is not done. Which is not done.
29/6/11.
I cannot make it done now. So it was, but my lord, that is why substantial question of law. That is why substantial question of law. So whether the learned courts below can reject a petition filed by the defendant and to produce a registered cell deed. It is not oral cell deed, registered cell deed. My lord, registration has a value. Registration, why it is registered? Registered document is above all.
Okay, anything?
Government takes revenue for that. And it is the main source of government revenue. So when I am paying some revenue to the government, and that is a very important document so far the immovable property is concerned, my petition was rejected. Court could impose some cost on me. But for that mistake, whether my case will go.
Now the question involved is your prayer for production of sale deed under order 8 rule 1A. You did not file it along with the WS. Later on, you prayed for submission of those documents. Which
That was my mistake, man.
Which was rejected. No,
Rejected.
That may not be mistake because under order 8 rule 1A, with the leave of the court, it can be added, it can be allowed later on also. But that petition prayer was rejected by the trial court.
Trial court.
Your mistake is you did not challenge that order.
But my lord,
Now, whether at the validity of that order can be questioned.
my lord, I have submitted a Firisti, it is in record. In Firisti, Matir Dolil, 1966, Matir Dolil, 1975. These are the two dates. Matir Patra Final, 2010. So these are in our name. So this
No,
are
but you have not deposited the
but
documents on which you relied.
documents, my lord, relied means what I will say, because it was not proved. It was
And
not
because
proved.
of that fact only, the trial court rejected your case.
But
That
trial
you-
court had some other options also.
No,
Other options
it,
also.
it was your duty. It is the duty of the defendant to produce document on which he relies.
But one thing, my lord, this is actually parties are not supposed to know the law. The law, if the lawyers commit some mistake, whether for their party will suffer. This is my self-acquired property.
Now at this stage. Okay, what else
It
is your
may be
submission?
any stage. Your lordship is a well-versed court. A court should give, everything is, my lord, I have seen it, everything is for the ends of justice. Now, if the party would have known about the law, that they would not have appointed any advocate. When an advocate has been appointed, it was the duty of the advocate to produce the document at the appropriate time. But he has not done this. That is why court rejected. He could come on CRP by way of filing CRP IO, but he did not do that. So for that, whether my purchased land will go, which I am possessing since 1966.
No, you are saying that it is your purchased land.
Yeah.
You have to prove that it is purchased land. For proving that, you have to produce the documents on which you are.
But where the lordship would also sometimes regarding others. Yes. My lord, here is the number of the deeds. Here is the number of the deeds, my lord. Our High Court, I remember one argument was advanced by a late senior advocate, Mr. Niloy Dotto, that our High Court has said that photostat copy of a document is also admissible.
Is also
Admissible.
admissible under certain circumstances.
Yes.
65,
Not
that
sure.
procedure has to, you have to follow that. Why you are relying on secondary evidence?
So, my lord, when there is a registered document, even court has the power whether this honorable High Court may also inquire whether any such document has been registered or not. Because land is in our possession.
I think under 100, it may not be possible, lordship.
No, it is
Unless
substantial
until
question of
lordship
law.
substantial question of law has been satisfied.
Substantial question of law, everything is for the ends of justice. Everything is for the ends of justice. Regarding other lands, here is like 41 bighas of land. Out of this 36 bighas are the suit land. I am not on 36 bighas. I am only for this 6 bigha plus donated 3 bigha. Now, so far donated land, because I do not see here the person who were present before the register. If that is, I think it is oral gift, but if the document is there, your lordship has said that I have produced the registered deed, perhaps.
No, the deeds which you have produced.
Or
just
deed, that is sell deed. Well, that
sell
is-
it.
that is
In
not
one
gift
deed, it is somewhere it is written gift deed. You see,
It is sell deed.
okay.
not give deed. So,
May I submit, Lordship?
Yes.
so my lord, this two deed gifts, number is also there. Number is, date is also there. One is 30/12/1966. Another is also 66. So since 66, my lord, we are 25. Kindly, Lordship, will kindly consider. In the criminal case, even there, if there is a very old case, normally instead of conviction, this probation or some fine is imposed.
Okay, let the other side submit.
So our case only on this, my lord, partition has been given, no problem. But our purchased land cannot become the subject matter of the, though we could not prove, but we tried, but we are not given the chance. Against that, we should have been calm, but we did not come. That was our mistake. But for the mistake, one immovable property will go from me, which is under my possession 6/66. That means 36 plus 25. 36 plus 25. That means I think 36 plus 25 also. 36, 46.
In this case, what happened,
47.
Lordship? There are two owners, Lordship, Komaruddin and Sahabuddin.
Let her submit. Yes.
Both the brothers are owners of the properties, Lordship. Sahabuddin was issueless, so he adopted a son, Lordship, Ismail, and he gifted 5 bighah of land in the name of Ismail. It is the case, Lordship. And as in the Mohammedan law, adopted son has no right to, Lordship, inherit the property of their father, Lordship. So there was a gift of 5 bighah of land in the name of Ismail. And thereafter, Lordship, Shahabuddin died, his wife also died. The entire property develops upon Komaruddin, Lordship. Komaruddin married 2 times. From first wife, the defendants, and from second wife, we are the plaintiffs, Lordship. So our case is that entire lands were inherited by Komaruddin. So as there was no partition, amicable perfect partition, so partition may be done in the name of the plaintiffs along with the defendants, Lordship. That is the prayer of the plaintiffs in their case, Lordship. Page 18, Lordship. For a declaration that the legal heirs of late Komaruddin have joint right title interest in the suit land according to Mohammedan law. For a decree to the effect that each of the plaintiff number 1, 2 is entitled to get 5 bighah 4 katha 6 to 3 lesser of land out of suit land. Plaintiff number 3 is to get 5 bighah 0 katha 434 lesser as per share in the suit.
Which page you are reading?
Page 18, Lordship, of the appeal memo.
Yes. Yes, yes.
Joint right title was claimed by the plaintiff along with the defendant's, Lordship. Paragraph B, for a decree to the effect that each of the plaintiff number 1 and 2 is entitled to get 5 bighah 4 katha 6 to 3 lesser of land out of suit land. Plaintiff number 3, wife of Komaruddin, Lordship, is to get 5 bighah 0 katha 434 lesser as per share in the suit land, and each of the daughter of late Komaruddin is entitled to have 2 bighah 4 katha 13 lesser as her share.
Who are the present appellants? Defendant number?
From the first wife, Lordship.
No, what is the number of their? In the original suits, they
Yes.
were defendant.
Yes, Lordship.
Defendant number?
1 and 2.
1 and 2.
Moghul Hussain and Afzal Hussain.
So
They are the,
how much they will get?
according to plaintiff, Lordship, equal to plaintiff number 1 and 2. They are brothers, Lordship. Alauddin Musammad Qutbanu Bewa, second wife, Lordship.
Okay.
3.
But
1
they are
and 2
claiming,
1 and 2 are
they are
brothers.
claiming that 7 bighas were sold to us and
Lordship.
3 plus bighah were gifted to us.
Lordship.
Therefore, this 10 bighah cannot be subject matter of the partition. That is their case.
Yes, their
Your
case
case is that they failed to prove the gift as well as the
is the
sale.
sale deed, Lordship. So entire property has to be, we have stated that this is the property of late Komaruddin. that is required to be divided among the children of the Kamaruddin and wife. One wife is alive, Lordship. So entire property is to be partitioned. That prayer was negated by them by filing written statement that no, B schedule land cannot be partitioned. It was already sold by Mohiran to Mohiran Nessa and then Mohiran Nessa to us. They have not exhibited the sale deed of Mohiran Nessa as well as Mokbul and
There.
Afzal, but they have exhibited the sale deed of Mokbul sold to his son and Afzal sold to his wife. And
Son's name?
Mokbul, Lordship, the sale deed I have. I've seen the exhibits, Lordship. Those exhibits they have exhibited.
And your submission is that those sale deeds does not help the
No,
defendant.
Lordship. Until and unless Mokbul and Afzal's title has been proved, they cannot sold out to their legal heirs, Lordship.
Regarding gift,
No, gift, Lordship, that is allegation is there that they already the suit land was gifted to them. That was not proved,
part of Suitland.
part of a scheduled land, Lordship. So when gift is not proved, Mokbul and Afzal had no title, Lordship. When they have no title, they cannot sell any land to their legal heirs, Lordship. So these sale deeds are irrelevant. This Mokbul sold to his son's Exhibit C. His son's name is Sharifuddin, Shahjahan Ali, Saiful Islam, Saidul Islam, Hokolure Pita Mohammad Mokbul Hussain, Jati Musalman Pesha Krisi, Sang Noagaon, Thana Manikpur.
Okay, what is your submission as regards the substantial question of law which was framed?
They have not proved the registered sale deeds, Lordship, until and unless they prove that there was a sale, there was a gift. This substantial question of law will not come, Lordship.
It will not stand
Lordship,
unless the,
unless they prove those registered sale deeds.
okay.
Both the courts held that after, Lordship, law and facts, Lordship, both the courts held that there was no endeavor from the defendant's side to prove those registered sale deeds. Had there been any endeavor, Lordship, they ought to have challenged those orders, Lordship, by which their prayer was rejected. That is on 29/6/2011, Lordship.
Okay.
They ought to have preferred civil revision. They did not.
Both of you, can you prepare a gist of your argument, written gist?
Written argument, Lordship, we have to prepare the entire case, plaintiff's case.
No,
defendant's case.
revolving around the substantial question of law only.
There are provisions to reduce evidence. They have not taken the recourse of those provisions, Lordship. Now, by
In the first appellate court as well as before this court.
Yes, Lordship. Moreover, in this case, what happened, Lordship, they have filed one regular second appeal that was taken an order 41 rule 11 column for 6 to 7 days, Lordship. Thereafter, the appeal was withdrawn with liberty to refile, Lordship. That second appeal was filed by only one appellant, Lordship. And later on, the second appeal was filed by 2 appellants. So liberty was granted by this Honorable High Court to only one appellant, Lordship. So I have raised maintainability of the appeal while the condonation application was taken for consideration. Learned High Court, Honorable Court had held that this ground you can take at the time of Order 41 Rule 11 hearing. But at the time of Order 41 Rule 11 hearing, Lordship, we are not heard. It was taken in absence of our presence, Lordship.
Your names are there, if do not come. My lord, kindly see page 91. That liberty is taken from the Honorable
In
High Court.
condonation application, your Lordship will find
Page
that
91, first, it is true, my learned friend has rightly said, first only Mokbul Hussain was the appellant, as this Jalal, another was not present, but the time is passing. So in that manner, my lord, only one person was the appellant. But the Honorable High Court, by order, kindly see page 95, last page. On submission of Mr. M.E. Mahmood, the learned counsel for the appellant, this second appeal stands disposed of on withdrawal with the liberty to file it afresh. So
No,
First,
that,
first,
that
Lordship, I
is,
submit that my learned friend, senior friend can reply, Lordship. Page 91, your Lordship will find enclosure 7. Page 91, Lordship. RSA 276 of 2018 by only Mokbul Hussain, Lordship.
yes.
Lordship, now page 95. This is
So
the
your submission is liberty is granted only to
order
Maqbul.
of Hussain. How this second appeal is maintainable in respect to the second appellant, Lordship. He did not prefer any regular second appeal before the Honorable High Court, and I have, Lordship, I have raised all these objections in my objection petition in the condonation application, Lordship. And at the time of hearing the condonation application, your Lordship may go through the condonation petition that was allowed.
No,
on
which was the
30.
case which was withdrawn 276.
Yes, Lordship.
Before this any RSA was filed.
No, Lordship.
So the second appellant, namely, what is the
Afzal-
name?
Afzal, Lordship.
Why Afzal do not have right to file the RSA?
He has not taken any liberty from the court to file. As because the
No, liberty is not required. Suppose he is approaching this court belatedly.
Lordship.
Delay
then
was already
condonation-
condoned.
then
Delay was condoned.
Lordship.
And therefore he is filing this app.
But Lordship, they have filed one regular second appeal by only one appellant. And that appeal was taken for
To
consideration.
him, liberty, he is coming on strength of liberty. But Afzal, for Afzal, question of liberty,
But in
and
the
it was condoned.
In the condonation, they have taken a ground that liberty was granted by Honorable High Court.
Liberty will be applicable only to
Mokbul, Lordship.
Maqbul.
So I have raised objection in my objection petition that this ground is not applicable to applicant number 2.
He can directly come.
He can directly
He
come
has come directly belatedly.
belatedly,
And
but
the delay has been condoned.
delay has been.
Then where
condoned,
is the
and
question of
At the
maintainability?
time of condonation, it was that maintainability of RSA by appellant number 2 can be raised in order 41 rule 11 hearing by Mrs. R. Chaudhary. It was recorded in the condonation application, Lordship.
Okay.
But
short
on the
answer.
day of order 41 rule 11 hearing, we took an adjournment, and later on when the matter was taken, we are not aware, Lordship. We have at the mention hour, we took an adjournment on that day. But when the matter was called and again it was heard, we are not aware about, Lordship, so we could not raise any objection.
Okay, your submission is now that he was not granted liberty, therefore he cannot come now.
Lordship. Already that point was considered by the Honorable High Court while condoning the delay. You can raise this objection at the time of order 41 rule 11.
Okay, you were not heard at that stage. Now you can make submissions.
Lordship, that is why I am pointing out that the earlier appeal was filed by only one appellant and liberty was granted to him, and thereafter the second appeal was filed with a condonation application. We appeared and filed our objection, then delay was condoned, liberty was granted to object. We could not object at the time of order 41. Now it's for the final hearing. But I will show from the record that, Lordship, this substantial question of law does not arise in this case, as because their DW1 were mentioning all the documents, but they did not adduce those evidence. And through the I have gone through the LCR, and thereafter I have obtained all the certified copies from this Honorable High Court only, the DW, PW exhibits, Lordship. From the LCR, I have seen A, B, C, D, E, F, G, H, I are there, Lordship. Up to I, certified copy was given to me. And registered sale deed by 1966, sale deed exhibit J, sale deed in the name of defendant number 1 and 2 by Mohirun-Nessa exhibit K, final patta in the name of six legal heirs exhibit L. But after I in the file, there was no exhibit JKL. So both the courts rightly held that defendant did not try to prove their purchase through from Mohirun-Nessa. So they have no right title interest over A, B scheduled land on the basis of registered sale deed. So these lands are entitled for partition, Lordship. Accordingly, preliminary decree was passed by the trial court. That was challenged before the Honorable First Appellate Court, and First Appellate Court also held the same thing, Lordship, without any exhibit, how they can pray for exhibiting those documents without any additional evidence application, Lordship.
Okay,
Well, my small
just
answer.
a minute, let her
And
complete.
then, Lordship, we have filed execution proceeding. After title suit judgment 10/4/2014, we have filed precept was issued, then first appeal came, Lordship. After first appeal judgment, again petitioners filed execution. Thereafter, execution was going on up to 1/2/2022. Thereafter, 7/2/2022, LCR were sent to High Court, and since then, execution is pending, Lordship. It's a preliminary decree, Lordship. 2014 judgment, and we are now on 2025.
Yes, anything else?
And
Yeah,
this substantial question of law does not arise, Lordship. There was no endeavor from the side of the defendant to adduce those documents.
to prove the sale deeds.
To adduce, at least to adduce, then to prove, Lordship.
Okay.
They have not yet exhibited. Question of proof will not arise, Lordship.
You submit a written gist of your.
Lordship.
Yes, Mr.
My
Mahmood,
lord.
what is your reply?
My
Brief,
lord,
brief reply.
regarding adoption, no doubt, in Mohammedan law, adoption has not so much importance, but speed is applicable. Just like in Meghalaya, Assam Land and Revenue Regulation is not applicable in Meghalaya, but speed is applicable. So that is there. The adoption which is available in Hindu law is not available under Muslim law.
No, in what context you are making this submission?
He
That
said that-
son,
I say that the
how is it is relevant?
adopted son was given, so foster son, fell and
Only
say,
I have stated to state the story of the
The
defendant.
5 bighas were sold to
adopted son.
adopted son because he will not inherit. That is her
Ah,
submission.
yes.
It
The
is,
adopted son,
That 5 bigha is also subject matter of the suit property. No,
No.
this subject matter of suit property is only 7 bighas plus
No,
3 point some.
The suit is 36 bigha or something.
Schedule B land
There will be like 36 bigha. More than 36.
of which you are claiming that
6 bigha should be out of the purview of partition. And second thing, my lord, liberty. Now, lordship, kindly see the last line, last page. The learned counsel for the appellant, this appeal is disposed of on withdrawal with the liberty to file it fresh. Now, lordship, here is a question. If Mokbul is the party, then withdrawal was unnecessary. He was already in party. So it was not clearly mentioned by the Honorable High Court that to add the party, but it is understandable because Mokbul was already party. For continuing the case, he did not seek any liberty because he was the party. Only liberty was taken because other party was not there, and he has his own right because he has also one of the purchasers. And thirdly, my lord, what is substantial questions of law? This is very important thing, my lord. Substantial question of law is this, which is very much important for a particular case, but which has not been properly discussed. So substantial question of law is this, which is lawful but not considered by the courts. Not considered by the courts. Here, the prayer of the appellant was that all are these Xerox copies of this cell deeds. Mohirunnisa as well as present appellant, Aladdin. Now, original deed is not found. So he has prayed, it should be brought. And order 12 gives him a right. And
No,
order,
this you have already submitted.
yes. So that was not properly given. The learned courts below could have imposed some penalty, but that was not done.
Our case is that lordship, that
Okay.
Kamaruddin was having 41 bigha, 5 bigha given to his foster son. So we have excluded that 5 bigha. Excluding that, only we have mentioned 36 bigha, 1 kata 5 lesa in schedule A.
Subject matter of partition,
Yes, lordship. Excluding that 5
of
bigha.
which he is claiming 9 plus bigha.
Their case is that lordship. that
7 bigha by sale,
By say
3 point some bigha by gift.
oral gift and 5 bigha to foster son from A schedule land. Their case is that.
But 5 bigha is outside the,
We have stated
How
that
they can give, my lord,
outside.
hey, very important question. How they can give 5 bigha to that person? Because he is not the legal representative.
No, lordship.
no, 5
Kamaruddin
bigha
He cannot give.
has been sold,
Gifted, lordship.
Gift.
has been gifted,
Now, my lord, is admitted,
sold or gift.
given, it is
Order
written,
in his
given.
foster-
How he can give?
Given,
He is
lordship.
not the legal heirs.
By which, by way of,
It is written as given, lordship. Out of love and affection. Where the
by
late,
gift.
yes, lordship, but that word is not there.
Registered deed is there.
No, so they called him as the foster son of Said Shahabuddin. So Said Shahabuddin, out of love and affection to his foster son, gave him 5 bighas of land out of A scheduled land. So there remains 36 bigha, 1 kata 5 lesa only in patta number 185, which is now A scheduled land.
Okay, you submit brief gist of your submission. Heard Mr. M.A. Mahmood, learned counsel for the appellant. Also heard Mr. R. Chaudhary, learned counsel for all the respondents. Stop. The learned counsel for both these parties are requested to submit brief, submit gist of, written gist of their argument. When? I'll give a fixed date.
Take 1 week, lordship.
Given
Done.
3rd or 4th November.
Lordship.
4th November.
Fourth one.
Place this matter again on 4th November
As part of.
as part of matter.
Public.